Well, good morning, everybody, and thank you so much for tuning in to another edition of Vastola on the Law. I am your host, Attorney Jeff Vastola, and I am here just about every single Saturday morning from 7:30 to 8 to give you free legal advice. Apologize my absence last week. I had a very sore throat, and the more talking I was doing, the worse it was getting. So I had to take a break last weekend. I hope that you didn't miss me too much, but I'm back. I'm live. It's June 26th, 2021, just to put a date on it. And call into the show. You just heard the number. It's 877-850-8585. Sharina is working with me today as the board operator. She'll put you live on the air with me. Just mind your manners. We don't want to hear the names of the people that are making you angry and that you want to sue, but let's put it into context and give me any question that you want, and let me do my best to answer your question. If I can do that right here and right now, then that's exactly what I'll do. If I feel I cannot answer your question, at least with good enough information, then I'll do the research that I have to do, and I'll get back with you the following week. Or if you want to reach me after the fact using my cell phone number, then I'll give you the information as soon as I have it. Now, if you want to talk to me about something in private, because I've been getting a lot of that feedback lately, people don't want to call the show because they don't want to share with the public what's going on, that's fine. Call me at 833-VASTOLA. That's a toll-free number which forwards to my cell phone 24/7, and you can reach me that way. 833-VASTOLA is 833-827-8652. So call me anytime. That forwards 24/7, and I tell people all the time, please call my cell phone at night, call me on a weekend. I may not be able to answer your question immediately or answer the phone immediately, but if you leave me a voicemail message, I'll get back to you when I can. And of course, if it's urgent, feel free to call more than once, because the reason I do all of that, to have a toll-free number that forwards 24/7 to my cell phone, is so that I can be a resource for you in a time of need. And typically what I find in what I do day in and day out as a personal injury lawyer is when somebody's involved in some kind of an accident, they typically have questions or sometimes even concerns. And so I like to be there for those folks as a resource to be able to answer those questions, hopefully alleviate whatever concerns you may have, or if I cannot alleviate the concerns, give you some good advice as to what to do next so that maybe you can minimize those concerns. We are very active on social media these days. I say we loosely. Lindsay in my office is responsible for doing most of our social media, but check us out on our website, which is vastolalegal.com, and you can find us on YouTube. We typically put these Facebook posts on YouTube, and I see that my mom has joined us this morning already from Tennessee. And good morning, Mom. If you wouldn't mind, type in something else so I can see that the Facebook feed is still live. It's difficult for me to determine these days whether Facebook is working or not. It's pretty frustrating, but today we have topics planned. I have topics planned based on things that have come up during my work week. My first topic is to be discussing Florida's contingency fees, and there she goes. Yes, looking forward to seeing you soon, Mom. How contingency fees work in the state of Florida. Mind you, I'm only licensed as a lawyer in the state of Florida, so my advice, if you're listening outside the state of Florida, may not be applicable to you. Just keep that in mind. But a lot of people ask, how does the contingency fee work? And frankly, it is a little bit confusing if you don't, deal with it day in and day out. Good morning, Don. Nice to see you. So I'll be talking about that, and then of course, referring to my Florida Law Weekly, I've got a couple of cases in here that I found to be interesting, so I'll talk about those as well. I got a real estate question during the week from somebody that called my cell phone, and so if I have time, I'll touch base very quickly on Florida's landlord-tenant statute, which is Chapter 83, so that I can discuss what I discussed with this caller earlier in the week. But most importantly, I'm going to remind you of the number to call into the show so that you can be live on the air with me between 7:30 and 8 o'clock on Saturday morning. That number is 877-850-8585. And as Many times as I've said that number, I don't have it memorized, which is why I keep looking over at my computer screen. 877-850-8585. I encourage you to call that number with a topic of your own. Now, if you don't have a topic and you can't think of something, that's fine. Sit back and listen. I am prepared to talk for 30 minutes, but we know from experience and listening to these shows after the fact that the shows are much more entertaining if there's some dialogue between people that are calling in and myself. So I do encourage you to call, interrupt me. Yes, I have topics to talk about, but please don't let me monopolize the time. Let's have a conversation. So if you've spent any time in Florida at all, and it may be the same in your state, and if it is, my apologies, because I really can't stand the advertising in Florida for personal injury lawyers. But if you've spent any time here driving up and down the highways, listening to the radio, watching the television, you are absolutely bombarded with personal injury ads. And one of the things that you'll see or hear very often is a free consultation, or we don't earn a fee unless we make a recovery for you. Now, those are all true statements. Those offering a free consultation offer a free consultation, and I do the same thing. Any lawyer practicing in the realm of personal injury or wrongful death or medical malpractice that works on a contingency fee is very likely going to give you that free consultation, because the nature of the contingency arrangement suggests we don't take any money from you unless we recover for you. So somewhere along the way, somebody decided to kind of spin that and say, let's call it a free consultation to make it look like we're doing something over and above what we already have to do. And the reality is, if you work in a contingency world, you have to give a free consultation. I mean, really, if you're expecting somebody to sign your contingency fee contract, you can't charge them money. So anyway, the contingency fee agreement is just that. It's an arrangement where your lawyer will work for you without sending you a monthly invoice, without asking you for a retainer up front, and ultimately does not get paid unless there's some form of a successful outcome, whether it's a settlement or whether you go to trial and a jury suggests that you win and the appellate process is exhausted and ultimately you win. Now, I will say, and I should say this at the outset, that there are certainly hybrid forms of a contingency arrangement, and when I do commercial litigation work, now it's been a while since I've done commercial litigation, but in my younger years I did a lot of commercial litigation. Commercial litigation is where you're representing a company or defending a company in typically a breach of contract action. It could be construction, it could be something like that, but it's not personal injury. When I was involved in commercial litigation work, I was representing an advertising company called the Yellow Book, and oftentimes customers would take out the ad would get published, and then they wouldn't pay for the ad. So it was my job as the lawyer to contact those individuals, try to make payment arrangements. If they wouldn't make payment arrangements, then we'd have to file the lawsuit. When I was doing commercial litigation working for the Yellow Book, I had a hybrid agreement, and that hybrid was a reduced contingency fee arrangement, and the company itself would pay all the costs. And the reason I did that was because there was so much volume that if I had to pay the costs for all of those cases and things, then I just wouldn't have been able to make that work. So understand that in a standard contingency fee arrangement, in a pure contingency fee arrangement, the lawyer pays all the costs. The lawyer pays the costs as an expectation of being reimbursed. So if you've been involved in a car accident, you may have very just blissfully signed away on a contingency fee agreement saying, yeah, this is just the way it's done. And frankly, that's true. This is just the way it's done in that environment. But know what you're getting into. Oftentimes, I sign up a client and there's an issue of sovereign immunity, which is governed by Florida Statute 768.28. And that statute specifically says that the attorney fee is capped at 25%. Now understand, under the standard contingency fee, which is found in the rules regulating the Florida Bar, by the way, the typical cap is a 40% cap if you're in litigation. So that statute reduces a 40% fee down to a 25% fee. And it's your lawyer's obligation to tell you that. So make sure that your contingency fee arrangement is contemplating a reduced contingency fee if you're suing the county, the state of Florida, Department of Transportation, Sheriff's Office, any subdivision or an agency of the state of Florida. You're going to have sovereign immunity there. So there are other situations where your contingency fee may be reduced for one reason or another. Now, I don't handle workers' compensation claims, so I'll defer to workers' compensation lawyers on perhaps what the fees are that are charged in work comp, but those are also a form of contingency fee arrangement. So the amount of the contingency fee, according to the standard schedule, will differ depending on where you are in your case. The easiest way to explain it is that if the case settles without a lawsuit being filed and the defendant filing an answer to the lawsuit, standard fee is 33 1/3. Now that can be negotiated up or down depending on the circumstances of any given case. But the Florida Bar suggests a settlement, or if a case actually gets filed but no answer is filed in response to the complaint, then the fee should be 33 1/3, which is basically a third of whatever the recovery is. Now, why did those authoring the rules regulating the Florida Bar include in subparagraph B that the attorney fee does not go up to 40% until an answer is filed in response to the complaint? Because they very easily could have said, okay, if the lawyer has to file the complaint, that means that there's not going to be a settlement voluntarily, there's going to be a fight, and it's going to be in litigation, which means it gets more expensive and it gets more timely for the attorney, which is the justification for the increase in attorney's fee. But why did they include the language to say, well, an answer must be filed to the complaint? And in my years of practice, I think I've figured it out. And that is because sometimes filing the complaint alone is a triggering mechanism to a settlement. Not very often, and I don't want to get anybody's hopes up, but oftentimes just the filing of the lawsuit alone can stimulate a settlement. And so for those reasons, I suspect those who are responsible for authoring the rule regulating contingency fee agreements stated it's not until an answer is going to be filed, which basically says, okay, it's game on, we're going to be in litigation for a while, that the attorney's fee is going to increase to 40%. But essentially that's what you're looking at. A standard pre-suit attorney's fee is a third. Once you get into litigation and the game is on because an answer has been filed to the complaint, it typically goes to 40%. Anything over and above 40% has to be approved by the court. And keep in mind that there is also a subcategory D that contemplates appellate fees. Because if you're involved in a car accident or if you're filing a wrongful death lawsuit and you've hired a lawyer on a contingency, the last thing you want to be told is, oh, by the way, we have to file an appeal or we have to defend an appeal, so go hire a lawyer and pay that lawyer by the hour for the appeal, because that could get incredibly expensive. And once again, the Florida Bar contemplated this, and so the Florida Bar included the contingency fee for the appellate services in subparagraph D, which says up to 5% of the award could be payable to an appellate counsel. Understand that a lot of trial lawyers, including myself, that represent people for an accident or a wrongful death claim, I can take the case all the way through trial. At least I feel I'm competent to take the case all the way through trial. And even if it gets sent back to be tried again, that's my job. What I'm not competent in doing, in my opinion, is appellate work. Appellate work is a subspecialty of trial law where not only do you have to know a separate set of rules, which I don't know, but just a tremendous amount of research and writing. Now, of course, I can research and I can write, but I don't enjoy it and I don't have the time for it. My practice is not geared for appellate work. So whenever I'm signing up a new client and I'm going through the contract, because I tend to do that, if and when possible, I will go through every paragraph of my contract and explain it. And when I get to subparagraph D of the contingency fee, section, I will tell people this is if you will need an appellate lawyer. No guarantee. Most cases don't require an appellate lawyer. But if you should need one, you would pay an additional up to 5%. So you would pay me a max of 40%, and then you might pay an appellate lawyer a max of 5%. So understand that you might be paying a total of 45% in attorney's fees. But I don't get that 5%. I don't even get a portion of it. There's no referral fee aspect to it. It's just, I will find you an appellate lawyer to help us, and you won't have to pay that lawyer by the hour, but there is an additional fee for that service. So essentially, that's how the contingency fees work in Florida. Keep in mind, I throw this out there to people that ask, or people that perhaps gripe about the 40%. I didn't make it up. The rule regulating the Florida bar, specific to contingency fee arrangements, has been there, I think, since the 1960s, perhaps earlier than that. So, yeah, probably before I was even born. So, I don't just whimsically say, oh, I'm going to take 40%. That's what's written in the rule, and that's what I apply. I apply the standard. You can deviate from the standard if you want, but then you have to get court approval and everything else. Some people think that's too much, and I can understand that. And so my response to them is, well, if you would prefer, you can hire me by the hour. My hourly rate when people ask is $350 an hour. Just this week, signed up a client who I'm already representing for a contingency fee matter, but she came to see me about something else, and she agreed to hire me at my hourly rate to do some hourly work, $350 an hour. But when people come to me for an injury and they're having a difficult time with the 40% fee, I'll throw it out there. Look, it's not mandatory. You don't have to use a contingency fee arrangement if you have an injury case or a wrongful death case or a medical malpractice case. You can pay your lawyer by the hour if you want to. In 25 years of practice across the board, when I throw that out there, guess what the response is? Oh, I'll just go with the contingency fee. Nobody wants to pay the lawyer by the hour when they have the option of the contingency fee. And I can understand that. But consider this. I'm not a financial guy whatsoever. I have a financial advisor of my own for a reason. But if you've got a case of significant value, consider what you're going to spend on the contingency compared to what you would spend on an hourly rate. If you have the money in the pocket to pay your lawyer the hourly rate, and if you have a claim of significant value, anything in excess of 7 figures or more in value, then consider paying your lawyer by the hour. Because when the case is done, now there's no guarantee. Nobody's going to have a crystal ball to tell you what the result is going to be and what you would have spent hourly versus what the contingency fee would have been. But there are contingency fees to the lawyer being paid in very large settlements, which are just staggering amounts of money. And if the client had opted to pay by the hour, it would be a very small percentage of what was actually paid. So something to consider if in fact you are a client. But then again, keep in mind that you can't force your lawyer to accept a specific kind of contract either. So those generally are my commentary on contingency fee arrangements. They're incredibly popular because there's essentially I don't want to say there's no risk to the plaintiff who's hiring the lawyer, because if you sign a contract on a contingency fee agreement and you give your lawyer authorization to file the lawsuit, filing a lawsuit in Florida as the plaintiff does carry risk, and I tell that to all my clients. The risk is if you go to trial and lose, there's consequences to that, and it's one of the cases that I have to talk about in here, so it's a good segue. But there's nothing that any lawyer can do about that. It's actually contained in Florida Statute 57, and it says that the party recovering judgment shall recover all his or her legal costs. Now, everything in the law is word specific. So the statute contemplates that the loser is going to pay the winner's costs. Understand that the word costs does not include the other side's attorney's fees. Okay, that's why we have to differentiate between costs and attorney's fees, and we always do that. Now, that same statute, Florida Statute 57, can also be used to seek an award of attorney's fees in addition to the costs, but that's completely different. What's automatic is that the loser pays. The loser pays the other side's costs. And that's always a risk. It's a risk if you're going to file a lawsuit in Florida. It's a risk no matter what kind of lawsuit you're going to file in Florida. And then I added on top of that, you have the potential risk for an award of attorney's fees in addition to the costs. And of course, the costs will oftentimes pale in amount compared to that of the attorney's fees. There are some statutes, there are some types of cases that are regulated by a statute that specifically say that the prevailing party is going to be entitled to an award of attorney's fees. So if you're going to be filing a lawsuit utilizing a statute in your favor, understand that that same statute may come back to haunt you, because if you don't prevail, the prevailing party is going to be entitled to an award of not just costs, but also attorney's fees. So what I was getting at is that even if you sign a contingency fee agreement with your lawyer, it's not a no-risk venture. Really what it is, it's an opportunity for you to have a lawyer get your case in front of a jury and not have to pay your lawyer by the hour or any kind of a flat fee arrangement. But ultimately, if you prevail, you will pay your lawyer. If you don't prevail, you will pay some costs and possibly even attorney's fees. That's an interesting case because it's a local case between two different law firms that I know about. Apparently they got into a dispute. One of them prevailed, was seeking attorney's fees and costs, and the ruling was, well, we're not going to give you the attorney's fees, but you're certainly entitled to the costs. Another case I wanted to talk about, I'm going to switch gears now. I'm going to talk a little bit about defamation, and in this specific case, libel. Two different types of defamation. You have libel, which is written, and slander, which is verbal. But they're both considered defamation depending on what's said. A false statement concerning another person. This is interesting because it has to do with a Facebook post. And I want to warn everybody, wow, my time is flying today. I want to warn everybody out there, be careful what you say on Facebook. All right? I have a client right now that I represent as the plaintiff, and we have filed a defamation lawsuit against another person because of what the defendant said on Facebook about my client. It was false, and it was published. And once you publish a false statement, a defamation claim is ripe. And that's exactly what happened here. You've got a plaintiff suing a defendant. Unfortunately, I say unfortunately because not because I want the gossip, but the facts of the case are not specified in the opinion. This is a venue ruling. The lawsuit was filed in Palm Beach County. The defendant who published something on Facebook about the other person lives in Martin County, and the defendant filed a motion to transfer venue from Palm Beach County to Martin County, and there's a reason for that. If I had time, I would get into it, but I don't. And a very lengthy opinion talking about the venue statute. So basically, the venue statute in Florida is Florida Statute 47, and it says actions shall be brought only in the county where the defendant resides, which would have been Martin County in this case, where the cause of action accrued, which is the crux of this opinion, or lastly, where the property in litigation is located. There was no property in litigation. That's for cases involving real estate. So this entire opinion, a very lengthy opinion, has to do with where did the cause of action accrue, because the defendant published the statement on Facebook in Martin County, presumably from his home, but the plaintiff was able to prove to the court that at least the first person that he heard from that said, hey, did you see or hear what so-and-so said about you on Facebook? That person was in Palm Beach County. And that's one of the elements of a defamation claim, is that the false statement must be published to a third party. And so because the plaintiff was able to prove to the court that a third party in Palm Beach County actually saw it, so that it was therefore published, this lengthy opinion ruled in favor of the plaintiff who had filed his lawsuit in Palm Beach County, and they said, we're going to keep the lawsuit in Palm Beach County because it was published in Palm Beach County. But the higher meaning, the message I want to get across to everybody is please just be careful what you post on Facebook. You know, don't gossip, don't publish false statements. Let's use Facebook to encourage people and lift them up. That's what we should be doing with Facebook, not tearing people down. So anyway, that's all I've got. I'm sorry, Sharina?
1 minute.
1 minute. All right. So let me just wrap it up with some self-promotion. If you want to talk to me anytime, if you have a question, if something urgent is going on and you have questions, dial 833-VASTOLA. That's 833-827-8652. And I mean it. Call me at night. Call me on the weekend. If I don't get to my phone and you have to leave me a message, please leave the message. If you have to call me back because it's urgent, call me back. And I will do my best to get back with you as soon as possible. If you want to find out more about us, go to vastolalegal.com. And thank you so much for watching. I hope everyone has a great weekend. Sharina, thank you so much for your help today. I appreciate it. Have a great weekend. And God bless.